Imagine thinking your inheritance will be split down the middle, only to find out your sibling was handed a valuable property before you even got a say. That's the kind of family drama that can turn an already emotional time into a financial minefield. Today, we're diving into a real-life dilemma. A viewer's parents promised a 50-50 estate split, but their mother decided to give their brother a piece of real estate before the estate was actually divided. Is that fair? And what does it mean for the person left waiting? Let's break this down. Estate planning is supposed to make things clear and ideally keep the peace. But as we see here, even the best intentions can get messy. The trust in this situation apparently spells out that everything should be split equally between siblings. So on paper, it's straightforward, a 50-50 split. But in reality, the mother gave the brother a property, possibly a house or a piece of land, before the estate was divided. Now, if you're not familiar, a trust is a legal arrangement where assets are held and managed by a trustee for the benefit of beneficiaries. In this case, the children. Trusts are created to avoid probate, minimize taxes, and, most importantly, to make sure the deceased's wishes are followed. But they only work if everyone sticks to the plan. So what happens when a parent gifts a major asset, like real estate, to one child before the estate is officially split? This is where things get complicated. First, we need to consider whether that gift was part of the inheritance or an extra bonus. Sometimes parents intend for a gift to be in advance on inheritance. Other times it's just that, a gift with no strings attached. But with a trust that clearly says 50-50 split, the expectation is that each child walks away with equal value, not just a split of what's left after gifts have been handed out. Legally, if the real estate was meant as part of the brother's share, the value of that property should be counted toward his half. For example, if the home is worth $500,000 and the total estate is $1 million, the brother's already received his share, and the other sibling should get the remaining $500,000 in cash or assets. But here's where family dynamics and legal realities can collide. Sometimes parents don't leave clear instructions, or they make decisions that don't get officially documented. Maybe the mother thought giving the property to one child was fair, perhaps because that child needed a place to live, helped out more, or for reasons she never explained. But unless the trust explicitly allows for this, it can be challenged, and often is. Let's look at some numbers. According to the Federal Reserve's most recent survey of consumer finances, about 17% of U.S. households expect to receive an inheritance, and the average inheritance is roughly $46,000. But when real estate is involved, those numbers can get much higher, and so can the potential for disagreement. In fact, disputes over inheritance, especially when it comes to property, are one of the top reasons families end up in court after a loved one passes away. So what should you do if you find yourself in this situation? First, check the language in the trust. If it says assets should be split equally, that includes accounting for any gifts given before the estate is divided, unless those gifts are explicitly excluded. In legal terms, this is called advancement. Most states require that if a parent gives a significant gift to a child before death, it should be factored into that child's share of the estate, unless the parent made it clear in writing that it's separate. But here's another twist. If the property was transferred while the mother was still alive, and she was of sound mind, it can be considered a valid gift. But again, unless it's excluded from the trust calculations, it could still count against the brother's share. If the trust was set up by both parents and the mother acted alone, there could be even more legal questions to sort through. Did she have the authority to give away trust property on her own, or did she overstep the trust rules? These are the kinds of questions that often require a probate attorney. In fact, legal battles over inheritance are so common that the American Bar Association estimates over 1 in 5 estates with property wind up facing some kind of dispute. And the emotional toll? That's a number you can't put on paper. Now let's talk about fairness. There's the legal side, what the trust says, what the law allows. And then there's the personal side. Maybe the mother felt justified. Maybe the brother feels awkward. Maybe the other sibling feels betrayed. It's easy to say just split everything 50-50, but life and family rarely fit that neatly into a spreadsheet. From a financial planning perspective, the lesson here is clear. Communication and documentation are everything. If you're a parent thinking about how to leave assets to your kids, don't just tell them your wishes. Put it in writing, make it part of your trust or will, and talk openly about your decisions. If you're an heir, don't be afraid to ask questions. And if something feels off, get professional advice before emotions turn into lawsuits. So, is it fair? Legally, probably not, unless the trust allows for it. Emotionally, it depends on your point of view. What's certain is that these situations are more common than you might think, and the best way to avoid them is with clear, upfront planning. If you found this topic helpful or have experienced something similar, let me know in the comments. I'd love to hear your thoughts. Don't forget to like, subscribe, and share this video if you want more real-world financial advice. And remember, when it comes to money and family, the best inheritance you can leave is clarity. What would you do if you were in this situation? Let's keep the conversation going.